both parties are interested, the court can help set that up. Or you may reach an agreement with the landlord, which would result in a conditional order of dismissal. Mr. Dutka, the Ambassadors for Christ Church owns this house on South Main Street, and they sort of try to provide housing for people that are in need of housing. She has a month-to-month tenancy, and at this point, they're asking her to move out.
That is correct, Your Honor.
Ms. Weber, what's your position?
It's, it's her house, she's my landlord, whatever she wants,
Well, the first thing we have to do is adjourn the matter 7 days.
Okay. I guess maybe I should talk to Carolyn then.
All right, well, that takes us to February the 6th. And then you would get 10 days from that day to move out or be subject to being evicted.
Mm-hmm.
So essentially that would give you until February the 16th to move. Do you think you could do that?
Yeah.
Have you got someplace to go?
No.
Yes, that's why you're there. Well, first of all, we're going to adjourn this till next Friday at 2:10. Does that work for you?
Next Friday.
February the 6th.
Okay.
Does that work for you, Mr. Dutka?
Yeah, it can. I would have to try to rearrange an appointment, but maybe
I can continue it to Monday the 9th if you'd rather I did that.
Let's see what I got going there. That's better, actually. Much better.
All right, well, let's take a look. That gives her a couple extra days.
Okay, February 9th?
Yeah, let's look at the calendar and see what time works.
Okay.
V9. 2:10 on Monday, February 9th.
That's fine, Your Honor.
All right, Ms. Weber. If they get what they asked for, they would get 10 days from that day, which would be February 19th for you to move. They're not asking you to pay rent. They're simply asking you to move. And I think there are 6 people living in this house, or I don't know. You just have the basement.
There's me and another girl.
All right.
That's the squatter.
All right. And where's the squatter?
Standing here.
Oh. Is the squatter in your room?
Yes.
All right.
The squatter's leaving today.
All right. That may be why they want you to move. That's you and all other occupants. Who's the squatter?
Megan Reed.
Okay. All right, if she gets out, maybe they'll have a different view of things. Who's managing this, Miss McNary?
Pardon me?
Who's managing the place?
Yes, Carolyn.
All right. Well, you can discuss that with her, but we're going to continue this till Monday the 9th.
Okay, and then after Monday the 9th, it's 10 days.
10 days from that day.
What would be the date?
February 19th.
Okay, I didn't know if that was a week or what.
But we'll address this further next 10 days from now on February 9th at 2:10.
Yeah.
All right, thank you.
That would be wonderful.
Okay.
Thank you.
All right, goodbye.
Thank you, Your Honor.
Bye. All right. Oops. I went to high school with Miss Weber a long time ago. And, she's just making her way through life. Okay. Thank you, Mr. Dutka. I'll see you on the 9th.
You bet.
And, bear with me. I'm going to do a couple general civil matters and we'll come back to landlord tenant. All right, it's 10:08, which makes us 8 minutes behind schedule, but all things considered, that's not too bad. The matter we're going to address right now is Velocity Investments versus Wendy Davis. Miss Davis, can you hear me?
Yes, I can, Your Honor.
All right. This is a claim for $1,797.73. It is a hearing today regarding entry of garnishments. A judgment entered in this matter some time ago. We had a hearing on April 23rd, 2024 regarding an installment payment plan. Then we had another hearing on May 20th of 24, and I signed it May 24th. Defendant has entered a payment plan of $65 per month. And then plaintiff has filed a petition for periodic garnishment of your wages, the Family Health Center. So set up for a hearing. Normally they can't do a garnishment when there is a payment plan in place. So Mr. Baxter, can you enlighten me here? Am I missing something?
No, Your Honor, actually, I have some good news for the court, Your Honor. Wendy Davis has paid the judgment in full with her credit card. We're hoping that that will go through and that we will not be before the court any further. We would still appreciate an order setting aside the installment payment order in case things go haywire, which we don't expect at this point. And that we hope to be filing a satisfaction of judgment with the court, Your Honor. So with that, I'll turn it back to you.
All right. Is that true, Ms. Davis? You used your credit card to pay this?
It was a debit card from my bank account, but yes, I was able to pay it in full.
Very good. I'm just gonna tickle this for 14 days to await satisfaction of judgment. If that doesn't work, I can set aside the installment payment agreement and allow garnishment to issue, but I expect that it will.
We would ask that you not enter the garnishment in the meantime. Maybe you were planning to do that anyway, but
No, I wasn't. I wasn't gonna do the garnishment in light of the fact there's an installment payment plan in place. I will not execute the garnishment.
okay. Thank you, Your Honor.
All right, Ms. Davis, hopefully this will all be resolved. The satisfaction of judgment is a document that says the debt is paid and there's no further action needed in the case.
Thank you, Your Honor.
All right, thank you. I hope your dog Bentley is more cooperative. All right, you're all good to go. Thank you.
Thank you, Your Honor.
Thank you.
Requesting that you turn your second here, your 382, to take it off the dock.
All right, I've got it right here. All right, thank you. Let me give you this one, Michelle. We'll wait 14 days. She's paid the debt. I think that one's gonna go away.
Do you want me to give these to the lady?
Please. All right, I have another matter which is set for 10 o'clock. It's entitled Credit Acceptance Corporation versus Andrew Babick and Morgan Olson Truck Body. Please accept this email as a formal request to withdraw our motion for tomorrow. This ended up being a garnishment defendant case. They got a judgment or asking for a judgment against the debtor's employer. Looks like it's been resolved. So they withdraw their motion for garnishment. When I don't know what the deal is, or I'm confused, or there's some issue, I set the matter for a hearing, particularly in the Zoom era, where the attorneys don't actually have to drive here. But what it usually does is get somebody to take a look at it and resolve the question. They had asked to seize property from Morgan Olson in light of this debt. I don't know if they were gonna go into the factory and take the equipment off the floor or what. So I set it for a hearing. The lawyers talked to each other and resolved the matter. In the last case, they had asked for a garnishment of wages when there was an installment payment order in place. And generally, you can't do that. So I didn't know what to do, so I set for a hearing, and that matter also looks like it's resolved. Pre-Zoom, they would have either had to send a lawyer out here from Detroit or hire local counsel to appear on their behalf. But with Zoom, we can generally take care of things remotely. That's a benefit for all concerned. All right, our next matter, Golden Pond Estates, isn't for a few minutes yet. So I'm going to do the order dismissing the matter in Singh v. Harris. Talk about boring, watching me write out a handwritten order, the epitome of it. But we do have a client here. Ms. Gritzmacher is here, and that's not a first case. I think everything else for the rest of the morning is a second hearing, so I don't need to advise her of her rights. And we've got several Golden Pond Estates, 2 Larkins cases. One has been settled. We have 5 cases left for the morning. Our next tenant is here. I'll bring her in and So we'll be ready as soon as the plaintiff comes. Both of these were non-payment of rent cases. And again, there's late fees and other things included in here. So hurry up and wait. They have a luncheon planned for Magistrate Luke, who's leaving today. I could smell the big crock pot full of soup, which is out the door. Miss Gritzbacher, can you hear me?
Yes, I can, Your Honor.
All right, very good. You're in the right place. Let me put you in the waiting room. I will wait for the attorney to come. All right, world's most boringest live stream. We've got a defendant in the waiting room. We don't have plaintiff's counsel yet, but the matter's not set for 7 more minutes. It's easier to just stay here and wait for the clock to tick than to stop it, start it. The old days, presume I would have just got up and left. Now I'm glued to this chair, which is why I'm shaped like a shrimp. call this a moment of quiet contemplation. All right, it's 10:27, 3 more minutes. We have 5 cases left. One is resolved. These next 2 Golden Pond cases, somehow as of late, the mobile home cases have become the most difficult. As I've stated, most, if not all, of the mobile home parks in the county have been purchased by large companies, have out-of-county counsel who represent lots of parties, and the whole landscape of landlord tenant law in mobile homes has changed.
Judge, I know that Attorney Cromendike is on his way. He and I were just on the phone.
All right, he's here. Mr. DeWitt was here, Mr. Sickle, and I was a little bit taken aback by all of it.
Good morning.
Good morning. Mr. Cromendike, I know you were disappointed, but you didn't get to come out to Centerville this week, but maybe we'll still get a chance.
I don't know what disappointed is the word, but
All right. We've got 2 Golden Pond cases set. We've got Golden Pond versus Gritzmacher and Kelly Cantrell. We were here last week and Mr. Sickle was here from Mr. Cromendike's firm. And we did get some struggles on trying to figure out exactly what was due and owing. Ms. Gritzmacher, can you hear me?
Yes, I can, Your Honor.
All right. I would also note that Meg Bauer is also present. She was privy to last week's discussions. She indicated you guys have been on the phone. Regarding Ms. Gritzmacher, she was going to try to get some emergency help from DHS.
I think we were on the phone about Cantrell.
All right, well, what do we know about Ms. Gritzmacher?
I have not had any communication with Ms. Gritzmacher or with Meg about Ms. Gritzmacher.
All right. Well, we
Legal aid has
determined that rent
no involvement.
was $1,614.59. She was included a $300 payment, $249.20 in costs, for a total of $1,863, and $300 was for repairs made. So at the time we were here last, through January, that was the amount due and owing. Do you agree with that, Mr. Cromendike?
Yes. Yes, I do. Those are the numbers.
All right. Ms.
that I'm showing from last
Gritzmacher,
time.
were you able to get any help?
I did fill the papers out, and at that time they said I need to redo another one. And I did take it, I did just, it got rid of my car, so to where come on the 3rd, I would be able to give $700 a month to get this all taken care of, so I don't lose my home.
Well, this is through January. There'll be another month rent due on February 1st. So the number I'm gonna give you is just through January. There's
Okay,
$1,313, $300 for those repairs that were made, and $249.20. This is through January. I used to add the upcoming month, but there was a hearing in circuit court on an appeal, and Judge Stutzman ruled that I can't do that. Some judges do it and most judges don't. At any rate, what you owe is $1,863.79 within 10 days from today, which would be, that's third isn't right. Today is the 30th. We do by February 9th. Now, Ms. Villa, the manager, is here. You indicated you've got maybe some help coming and you plan to try to pay an additional $700.
yes, on the 3rd, I always get my checks, and with my check, and I just rid of the car because it's not running, get in trouble out here. And I got in my Social Security check and put with that, and I would have $700 this month.
All right. Now, my suggestion is that you contact Ms. Villa today and discuss this with her. I'm gonna tell you something.
Who is that?
She's the manager at Golden Pond.
Okay, see, I did not even know who the manager was of Golden Pond.
All right, well, there've been a lot of
I thought
changes
it
there
was
since.
KC Villa.
Yes.
Okay.
All right, let me repeat. You owe $1,863.79 by February the 9th. If you don't pay that amount, you're subject to have them take your trailer off the lot. You don't have to move out, they're evicting your trailer because you own the trailer and they own the lot. This is lot rent. Now, they don't have to do that. In fact, it's in their interest not to do that. It's in their interest to try to work out some sort of payment agreement with you so you can stay there. You have to pay the entire amount. A partial payment will not prevent the writ of eviction, and there is no money judgment due. However, well, they did ask for a money judgment. So I guess I'll issue it. This is only through January. Do you understand, Mr. Cromendike?
Yeah, yep.
All right, there's a money judgment of $1,747. So my strong advice, Ms. Gritzmacher, it sounds like you got a plan to pay this off. They don't have to evict you on February 9th. They have 56 days from today to ask for the writ of eviction and another 56 days to serve it. So they have about 100 days they could agree to work with you to try to get caught up on this rent. And it's in their interest, so they don't have to hire a company to come in and have your trailer taken off this lot.
Okay, Your Honor, I got a question. You said they did $300 maintenance. What did they do for me for $300?
Well, we discussed that last week. Let me see if my notes tell me what that was.
And I can help you out on that too, Your Honor.
Yeah.
If you'd like me to. That
Yes.
is that's relating to some skirting repair. And I'm actually looking at a skirting installation payment agreement here, where you had agreed, Ms. Gritzmacher, to pay $100 a month. So they paid 2,000.
Yeah.
I'm sorry?
Yes, you're correct on birding.
All right,
Okay.
very good. All right, now do you know how to get a hold of Miss Villa?
No, I don't, Your Honor.
Ms. Villa, could you join us, Ms. Villa?
Oh, I'm sorry, I'm on mute. Yes, Your Honor, good morning.
How does she get a hold of you?
Yeah, we have a phone number, sir. And I've been speaking with her previously.
All right, well, I'd ask you to stay in contact with her. And if you're gonna work out some repayment, I think that'd be best for all concerned.
Mhm.
All right, she knows how to get a hold of you. And you guys can discuss this further. I think you're gonna work this out, but let me repeat. Be a $1,863.79. There'll be an additional $400 due on February 1st. So the amount's gonna be $22.63, perhaps plus a late fee. You're proposing to catch it up at paying $700 on a $400 a month lot rent. They can agree to do that, but they don't have to. That's why you need to stay in contact with your manager. All right. Ms. Villa, will you call her today?
Yes, Your Honor.
All right.
Your Honor, I need to give her my new phone number.
All right, let me put you guys in a breakout room because I don't want you to put that out over the live feed.
Okay, thank
And you
you.
guys can exchange contact information.
Got it, sir. Thank you.
Judge, I am wondering
Thank you.
if you can spare a few minutes that Ms. Cantrell and I might be able to speak in a breakout room.
Yes, let me,
Unless she objects
this
to
should
that.
just take a minute. And you guys join that room and then Ms. Villa, if you'd come back to us.
Yes, Your Honor.
Judge, are you putting that judgment together, or did you need me to do that and submit it?
You sent me one, so
Oh, we
I've
did.
done
Okay,
it.
perfect.
So I appreciate that. All right, Ms. Cantrell, can you hear me? All right, this is another Golden Ponds case that we struggled with last week with Mr. Sickle. And it's entitled Golden Pond Estates versus Cantrell. Once again, their manager Casey Villa is here. Defendant Steve Cromendike. And Meg Bauer. Miss Bauer and Mr. Cromendike have been discussing the case. Last week, we came up with $1,932, late fees at $60. There was other utilities for November and December, $249.30. We came up with a tentative figure of $2,306.45 through January. There were water bills, utility issues, and $72 per month for sewer and water, and it was hard to exactly pin the number down. You guys have been in discussion. Ms. Villa has joined us, so let me put Ms. Bauer. Well, all right, before we do that, what number are we working from, Mr. Cromendike?
That you had $2,306.45.
Yes.
Yes, that's my understanding of what the number is as well.
All right. Ms. Cantrell can hear me. She's there. Let me use the breakout room. And I'll move. All right, I'm going to put Ms. Bauer And Ms. Gritzmacher, I'm just gonna remove her.
Okay, Your
All
Honor.
right. What's that?
I said, okay.
All right, you're good to go. So let me do Kelly Cantrell to room 1, legal aid to room 1. All right, you guys can talk privately. Ms. Gritzmacher, I'll remove you and you can go on with your morning. Meg, did you get the join button?
I did. I see Miss Cantrell's still here. Miss Cantrell, did you get a
She's,
oh, there it is.
she's gone.
Okay, thank you.
All right, I have then with me Andrea and Brady Watson. And I have Andrea Watson also. Mr. Brady Watson and Miss Andrea Watson, this is file number 252671. Your lawyer has filed, or the lawyer for the Larkins has filed a conditional order of dismissal. They find that the amount due is $4,009.93. You agree to make weekly payments of $450 every Friday until the balance is caught up. This will take 19 weeks. They further agree that if they miss or have any late payments, they can result in an immediate eviction. So you've agreed with your landlord to pay an additional $450 per week to get caught up. Is that correct?
Absolutely,
Yes, Your Honor.
All right, well, Ms. Watson, you look like you're out in the cold. I've signed that conditional order of dismissal. We'll make sure you get a copy of it. You can both go on about your business and the matter's dismissed. If you hold up your end of the deal, it'll take care of it. If you don't, they may ask for an immediate eviction. But
Okay.
you're good to go.
Right, thank you, Your Honor.
Thank you,
All
Your
right,
Honor.
thanks. All right. That takes care of our 1050 case. Good morning.
Good morning.
Mr. Larkins, Andrea and Brady Watson were here, and Mr. George filed on your behalf a conditional order of dismissal. I went through the terms of that dismissal with them, And they were in agreement, they're gonna pay an additional $450 a week to get caught up. And then I released them. So I signed that conditional order in the Larkins versus Watson case.
Perfect.
Then we have Larkins versus Craig, which isn't set till 11. So we're in the middle of another case. And Miss Wessel is here. Her matter is set for 11:05. So we've got people in the waiting room or in the breakout room discussing our prior case. So we're in pretty good shape for each of your cases. Let me put you each in the breakout room and see where we are. So I'll see you in a bit. I'll put you in the waiting room, excuse me, not the breakout room. And I'll bring you in when somebody shows up. Miss Wessel, I'll do the same with you. We'll finish Golden Pond Estates, and that leaves 2 matters yet to be resolved. More of the world's most boringest live stream. All right, Mr. Larkins isn't set till 11. So looks like Meg is back. Let me close the breakout.
I told her to stay there, Judge.
Okay.
An issue
Mr. Commandant, would you join us?
to light. Steve, did you get the text I sent you?
I'm getting it right now.
I don't
Yeah.
like to spring things on my colleagues. This information is just coming to light to me now, but it actually connects the dots on some other pieces that I've gotten from other cases. Judge, I apologize for doing this on your docket, but are you willing to let Attorney Cromendike and I speak for a minute?
Sure,
can give you
that's fine. I can skip ahead to the next case. So I've got to bring her out of the breakout room. I want to put you in there. So let me move her out.
Okay. I mean, the other thing is we can just mute each other or ourselves and have a phone call.
Well, let me put you in the breakout. She's not moving out of there. I'm gonna close it.
That's probably because I told her to stay put. That in the moment seems strategically like the right decision.
All right, she's back. Let me know. Start over.
But we're gonna jump in with just you and I, Meg.
It might not actually be a bad idea I'll defer to you on that, Steve. I'm okay with bringing everybody in.
Okay, that's fine.
All right, I'll put KC in there. I'll put Cantrell in there, and I'll put Cromendike in there, and I'll put McBauer in there. And then I'll work on some other cases.
Thank you, Judge.
Hi.
Although, Judge, did I get reassigned? Actually, Judge, you're muted now. Thank you.
All right, Mr. Larkins, can you hear me?
Yes, sir.
All right, Miss Wessel, would you join me, please? And Lacey Grice.
I'm here.
All right, this matter isn't set till 11:05, but both parties are here, and so we're gonna address it. Mr. Grice, can you hear me? Miss Wessel, can you hear me?
I can hear you.
I can't, your picture's frozen. Mr. Grice, can you hear me? Well, I was gonna try to start early. I've got someone that's logged in as Lacey Grice. Can you hear me? Uh, you've logged in. I can't hear you or see you. You've got your camera turned off and your microphone turned off. Lacey Grice, would you please join the proceeding? Well, we can't do anything. Mr. Grice, I'm gonna remove you, log back in and see if we can get connected, but we're not accomplishing anything by you sitting there with no response.
She did just message me and it's telling her that the meeting link is invalid, but I told her to try it again. Because it
It's a
says she
her?
was
I thought it
invalid.
was a he.
No, it's a her.
Okay. Well, the meeting link wasn't invalid. She was sort of halfway in.
Yeah.
I didn't make very good notes. We've got plenty of time. We're not on a time crunch, but I would like to get at it. Ms. Thorne and Mr. Larkins are waiting for their tenant, Mr. Craig. All right, here's Lacey again. Let's see if we can get her in this time. I think we're closer. All right, Ms. Grice, you've got your microphone muted and your camera turned off. Can you hear me? Turn it on for a minute. I'm going to ask ChatGPT why everybody on social media has a picture in the passenger seat of a car.
Okay, can you hear me?
Yes.
Okay, hold on. Let me try to figure out how to turn my video on. Start video. Can you see me?
No, unless you're in a dark room with no light.
No.
A black cat in a cold bin at midnight. Well, Miss Wessel, could you turn your camera on?
Mirror my video.
All right. Let's trudge ahead. We were here on January 23rd. The title of the case is Riley Wessel versus Lacey Grice. Ms. Grice is here by audio and Ms. Wessel is here with audio and video. We determined that the arrearage through January was $4,287.20. That would be $4,200 in rent and $1,000 of rent plus $50 a month late fees and court costs of $87.20. Ms. Grice had applied for some assistance. I'm not sure what the status is. Ms. Wessel, what's the status here today?
So she had her interview with DHS today. And so that was the farthest we've gotten, I'm pretty sure, with DHS.
Yes.
So I think we're just waiting on them to accept her. She has given me like 1 month of rent so far, and now we're just waiting on DHS.
So she did pay $1,000?
Yes.
You agree with that, Ms. Grice?
Yes, Your Honor. I gave her $1,100. I've been paying her since the last court date. I've been working to pay off this month's rent. That way, if DHS helps me, that way I don't keep getting further behind.
All right, very good. Now she said 1,000, you said 1,100. Did
It's
you accept
1,100,
the?
my bad. Yes, 1,100.
All right.
Yeah, because it's late,
All
so
right.
I gave her an extra $100 because it was late.
All right. Well, I'm going to subtract 1,100 from that figure. 4,200 minus 100, 1,100 paid is 3,100. plus 87.20. The amount due is $3,187.20. Now, on Monday, another month's rent is going to be due. This order is only through January.
Yes,
So,
Your Honor.
fine.
I've spoke with Miss Wessel, and I get my caregiving check. I claim my hours at the end of this month, so on the 31st, and then my check will get sent out the second Friday of February. And I told Riley that I will give her we'll get February's rent as soon as that check comes. And then if DHS does help me, this is the farthest we've got with them. They just kept denying me before, saying that I was in non-compliance for child
there's
support.
those child support issues.
Yeah, but it was an error in the system. So I just got done with my interview before our court date. And so I feel like that's a good sign because we couldn't even get that far before. But if they do not help me, then I told Riley that I will give her my tax return to get caught up if need be.
All right. There's a lot to unpack here. The debt was $4,200. You paid $11,000. That pays through January of 2026, $3,100 is the amount of rent due and owing. $87.20 are the court costs for a total of $3,187.20. On February 1st, another month's rent is going to be due. A partial payment will not prevent the writ of eviction, only the full amount. Ms. Wessel, you may know this, but I want to make sure you both understand. You don't have to ask for the writ of eviction on February 9th. You have 56 days from today to ask for the writ of eviction and 56 more days to serve it. So you can agree to work with Ms. Grice to get caught up on this. And it sounds like that's what you guys intend to do, is for her to get caught up. Is that correct?
Correct.
I don't know why my video's not working.
But the only thing that will actually cure this is paying the entire amount. By the letter of the law, she could ask for a writ of eviction on February 9th. And it as always makes more sense to keep a good tenant in there than to move one out and move another one in. So Ms. Wessel has 112 days worth of discretion to kind of get caught up on this before she seeks the writ of eviction. But the amount due is $3,187. There'll be another $1,000 due. It looks like you paid January, and then you're going to try to pay February.
Yes, sir.
This is income tax return time, and the number of landlord tenant cases goes down during income tax refund time of the year. People pay on their probation oversight fees, they pay their court costs, and they pay their rent. So Ms. Wessel, it sounds like the two of you have a good working relationship. Hopefully she can get caught up in this rent. You guys can maintain this tenancy. Do either of you have any questions?
I do not.
I do. I wish you could see me, but so what is happening on February 9th, sir?
Well, she can evict you if she chooses to.
Oh, okay.
She can ask the sheriff.
Oh, okay.
She can have the sheriff come put all your stuff out in the street. She doesn't have to, because she can agree to work with you for up to 56 days before she asks for the writ, and 56 more before she serves it. But this order says you owe $3,187.20 by February the 9th, plus an additional $1,000 for February. So it's by her good graces that she's going to try to work with you to get caught up on this rent. But you got a plan, you got some lump sum money coming in, you may have a tax refund. which could pay this, and then you get squared away maybe by March 1st and start fresh with March's rent. But that's what this order says. You do have 10 days to appeal it, but I think the two of you are going to work on this.
So
I can't. Can
when
you
I
see
get
me?
caught up, I can see you. I don't know why you can't see me. When I do get caught up, would there be a way for us to like get it off of my record so that it doesn't prevent me in the future from?
Well, it won't show as an eviction. It will show as a judgment. Yeah, I guess you could file a conditional order of dismissal or something after the fact.
Yeah,
but
after.
for now, this is going to go on your record as a landlord tenant judgment.
Okay.
All right. Excuse me. Good luck to both of you.
Thank you.
Thank you.
All right. Someone's joined us by telephone. Is that Johnny Craig?
Yes.
Yes, I have two more. All right, the title of this case is Annette Larkins and Scott Larkins. I gave her first billing versus Johnny Craig. Mr. Scott Larkins is here along with his property manager, Caitlin Thornton. He was not here last week, and Mr. Tim George appeared by limited appearance on behalf of the plaintiffs. And that worked out pretty well, Mr. Larkins, for what it's worth. Mr. George did a fine job. We determined at that time that rent was $1,975 as of January 15th. $120 in late fees at $40 a month for a total of $170.22 for a total of $2,265.22. Defendant indicated he'd been ill. It was also construction season and it's cold out, and he would like to get caught up on the rent. What's the current arrearage? You guys are on mute.
Sorry about that. We are at $2,265.22, though that does not include February's rent.
All right, so same as last month.
Correct.
Or last week through January. All right, Mr. Craig, what's your position?
It's looking like I'm gonna have to just move, but I plan on paying these guys the money that I owe. I don't have it right now. I'm not gonna be able to have it in time to save my apartment. And it sucks because, it's a good place to be. I appreciate, Caitlin and Scott for helping me out, but I just got so far behind that I cannot catch back up between, my child support alone is killing me this week. So.
Oh, do you have a tax refund coming?
Yeah, but I'm not sure how much it'll be. I haven't gotten filed yet. I just got my W-2s a week or two ago. I think last week I got them.
All right, well, I'm gonna make a finding that you owe $1,975, $120 in late, and $170.22 in costs, for a total of $2,265.22. That's through January. There'll be an additional, I think it's $875 due on February 1st. The date for the writ is 10 days from today, which is February the 9th. So you should plan on moving, if you're going to move, by February 9th. Mr. Larkins can agree to work with you for up to 56 days, but it doesn't sound like you're gonna be able to come up with a rent and you're just gonna have to move. He has a waiting list of people that are waiting and would be ready to rent this apartment and pay rent.
Yeah, I know.
I'm not asking for a money judgment at this point. After you move out, he can ask for money damages. When you do move, you need to turn in your keys and give your forwarding address to the landlord in writing within 4 days of your moving. That'll trigger the security deposit law, and he can apply your security deposit to any unpaid rent or utilities or other costs. But the amount due to redeem this is $2,226 or $2,265.22. If they do agree to work with you to get caught up on this, that's something they can deal with. But at this point, I'm simply entering the judgment. Unless otherwise some resolution is made, you should plan to move out within the next 10 days. If you don't, you're subject to having the sheriff come put your stuff out in the street. Again, when you move, you need to turn in the keys and give your forwarding address within 4 days of your moving. Do you have any questions?
No, Your Honor, I appreciate it, and
All right, well, you know how to get a hold of them. You stay in contact with the management. And Mr. Larkins, you can decide to work with him if you wish to, but you certainly don't have to. He's pretty straightforward and honest about his circumstances. So, Mr. Craig, you're good to go. I hope work picks up as the weather gets warmer.
thank you, guys.
All right, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. All right, Meg and Steve, we have cleared out all the other cases while you guys were in the breakout room. We did the next couple of matters, so this is the last one on our docket.
I mean, I
So
do
we-
have a way of clearing out a room sometimes, Judge.
Yes, thank you. Everybody left. All right, everybody's back. We return to Golden Pond Estates versus Cantrell. Kelly Cantrell is present. Mr. Steve Cromendike is present for the plaintiff with their manager, Casey Villa, and Meg Bauer is here from Legal Aid. So where are we now?
So, Judge, it has come to our attention mutually that there is an issue with the running water in this park. We've known some of that, but what I mean is it appears, we don't know the source of the issue, but it appears as though the main lines in this park are frozen and that many or many residents in the park are not actually receiving running water. Upon investigation, the conclusion seems to be that that issue is below the grade, meaning that the responsibility for addressing this issue lies with the park and not with the residents who own their homes. For residents that are renting homes, it would still lie with the park. But in this case, this is a resident-owned home, and the resident has taken appropriate measures to ensure that water would be running from her trailer on her end, and upon some diagnosing, the water lines seem to be frozen on the park's end. Or if there's some other issue, whether it's that the pump is broken, we won't presume to know.
Ms. Cantrell, right now you have no water?
No,
No running water presently?
no. And I had a salamander underneath my trailer for 6 hours last night. And I have also replaced the heat tape to make sure it's working properly. All of my water lines have been insulated with fresh insulation.
Well, we don't know. It wasn't as cold as it was supposed to be. It was supposed to be about 4 degrees. I think it got down to about 15. We've had colder nights. So right now, we don't know whether it's your trailer or the park, but your contention is other units also have no water?
Yeah.
That is knowledge that I have as well, Judge.
And just to be clear,
Everybody out of water?
That is unclear. I'm sorry, Steve.
No, I was just gonna say, this is the only one that I have heard about so far.
But it does appear the park has received other reports.
Well, it's very cold, and so if 8 trailers are frozen and 32 are not, it seems like the problem is with the individual trailers. So we don't know yet what the distinction is, but we do know at this point, Miss Cantrell doesn't have any water.
Attorney
So what does
Croman,
that do to our circumstance?
yeah, we proposed asking for an adjournment. We have some discussion. We've been in discussion about the numbers, and it's not inconceivable that we would reconcile them. The absence of water falling on the park does raise concerns about lockout claims.
Well,
But
it's your contention that it's on the park. It's that's not clear yet, but
yeah,
like I said, if there are a number of trailers that are unfrozen, that makes it less clear.
it does depend on how the lines run. But attorney, I think what I had sort of thrown out, and I think we were all on the same page of, is asking for an adjournment so the park can investigate this water issue. If the park can get water to the residents, I think we can reach resolution fairly quickly and easily, at least with regard to the non-payment of rent case. What it will take for the park to address its own water issue, if that is in fact where the issue lies, is perhaps at the park's discretion. But for purposes of resolving this case, if we can get some answers and some clarity on this, I think we can get it resolved. But we would need some time to do that.
All right. Mr. Cromendike, how are you regarding the issue of continuing the matter?
No, I'm in agreement. Yeah. I mean,
Ms. Villa, can you hear me?
Yes, Your Honor.
Are you on site at the park or are you someplace else?
No, sir. I am remote.
Have you heard other issues about people with frozen pipes?
We have received reports of some pipes freezing, but this is obviously due to the weather. So we've advised most of them to leave a trickle of water.
All right.
Which is an
Kind of
additional.
minimize this.
Which is another issue. If
Sure.
you leave a trickle of water, it increases their water bill. All right, so there is issues with frozen pipes. Here we are in 2 in January. Well, let's pick a date to put this. I'm gonna be going on a trip again. Apologize, but I have an important meeting on Duval Street in February.
Judge,
I
you're
think
going
we
all the way
talked about
down to-
February 27 yesterday.
Oh, that far out?
Well, I don't know.
Certainly. Well, I'm willing to go. I was gonna go the 13th, but if you want to go all the way to the 27th, I'm agreeable with
Let me
that.
look at the 13th. I'd be open the 13th as well.
right,
Actually, I'm
let's
sorry. I'm out of town the 13th, so that would not work.
Oh, I think, didn't we just didn't we just do this another case?
We did.
Yeah,
I'm
let's
out of
see.
town the 13th. You're out of town the 20th.
All right, let's
16th is
look. Are you on Duval Street?
I won't be seeing you there.
Okay, well, maybe it should be.
Might be nice to see outside of a Zoom room here, but you know.
All right, let's be 27. Yeah, I have a Golden Pond case set for that time at 11. I'll set this for 11:10 on February 27th. I think you guys are working on the other case also.
Yeah.
That's Golden Pond. I'm not sure what that is, but
That's Miller Ann's.
Miller Ann's, oh boy.
But that's a
I
status
blocked out a
conference,
whole
Judge.
hour. Let me put this
Oh.
before that rather than, I'll do it at 10:50 on February 27th. Ms. Cantrell, I don't know whether the water issue is your pipes or the park's pipes or both. If you do get it running and you have to leave your water running, make a note of when you turn it on and when you let it run, because this happens in Three Rivers too. Some of the apartment complexes suspend water fees while you are letting the water run. Plus, this fills the septic system. If everybody's running their water steadily, they're gonna have problems there too, but it's probably less of a problem than frozen pipes. And if they burst, which one did here at the courthouse last Thursday and flooded my office, it's unpleasant all the way around, except your pipes are underground, ours are overhead. All right, you guys have been working diligently on this, what I appreciate. We're gonna continue this to February 27th at 10:50 a.m. All right, thank you all. Anything else we should place on the record?
Nothing for me.
Not
All
from
right,
the
thank you. You're all good to go.
Thank you, Judge.
Thank you, Judge. And that concludes your docket then, right?
Yes, it does.
Thank you.
Okay. Have a good weekend, Judge.
Thank you. All right, that does complete my docket. I don't know if I have any emergency things or other things I have to do this afternoon. But what I believe it does is it finishes Friday, January 30th. Also finishes the month of January. For those of you that were watching, I apologize for the dead air and the boring parts, but that's how it is. Anyway, I will see everybody. Hope you guys like Sheryl Crow. That's what you got today. And we'll be back Monday with a civil docket and a criminal docket. All right. got all my files stacked in here because my office is such a mess because of the flooding, but I have this matter here before me. This is another continued hearing in the matter of matter of Colon Township versus Alfred E. Yoder and Joanne Yoder. There are two files, 25040CZ and 25533CZ. These are circuit court matters. I inherited this case earlier this year from Judge Stutzman when he disqualified himself, made a number of rulings, had a number of hearings. Keep hoping this matter will be over and completed, and the defendants have filed additional pleadings. I'm not sure I exactly understand everything. And then again, some pleadings were filed just the other night, January 21st, which was Wednesday before the pipes broke. So I had made my rulings. Mr. Thornton, on behalf of the township, submitted the orders for presentment. Defendants filed these additional pleadings, and here we are again. Mr. Thornton has filed a response pointing out the irregularities in the defendant's motion and pleadings, and he's asking for sanctions on behalf of the township for continuing to have to come back here regarding these motion hearings. So, Mr. and Mrs. Yoder, you're the motion filer here. What are you asking me to do?
Your Honor, we're here on our written motions challenging the accuracy of the proposed order and opposing sanctions.
All right, what's your challenge to the accuracy of the order?
It's very misleading. And it does not match the transcript, not even close.
What part of it don't you like?
Most of it.
Well, my reviewing of it is it was consistent with the orders I made here in the courtroom. They don't have to exactly track where it was said in the courtroom. You filed these pleadings, and as I've said repeatedly, someone's helping you, someone without a law license, but access to Chat GPT or other AI generated stuff. They're terrible. Their pleadings are terrible. They're leading you down the incorrect path. They're going to end up costing you lots of money, and they filed fraudulent or incorrect, at worst, fraudulent, at best, incorrect or lazy or incompetent pleadings on your behalf. They cited authority that doesn't exist. Anyway, and then they can't speak for you because they aren't lawyers. And I can't go back and redo the past. I told Ms. Wertelman this, I told others. If you had a competent lawyer at the start, we'd have been a lot better off than we are here.
But, Your Honor, what do we have missing?
All right, well, we'll get to that. All right, so you tell me you file these things and you object to everything in the order. You don't like anything that's in it. I need you to be a little more. Now, you do have these pleadings that you filed, which state these things. All right, well, all right, so you've got defendant's motion order to show cause in 2540 and 25433. And you've got a motion to strike proposed order of December 4th. Law requires that a written order match the oral ruling. Proposed order mischaracterized what the court actually did. The judge may lock himself to avoid judicial duty. And then eventually object to the entry of proposed order. So that's the first thing. You're objecting to the entry of the orders. Mr. Thorne, what's your response?
Your Honor, the court's rulings in the hearing held in both of these cases on December 3rd of 2025 were not extensive or complicated. The two proposed orders that I prepared at the court's request with regard to the denial of the order's motions on December 3rd, 2025 are brief, accurately reflect the court's rulings on that date, and if the orders had competent counsel, would have entered without objection. Well, that has not been the history in these cases. Instead of those simple, straightforward orders being entered by the court, the orders file a motion to strike, 9 pages long, a motion for an order to show cause, 6 pages long, objections to entry of proposed order, 8 pages, and then a week or so later, an affidavit of factual observations, 5 pages. The orders in violation of the court rules then failed to follow the court rules by failing to serve those documents on me as the township's counsel of record. The orders in violation of the court rules to file with the court or serve me with a proposed order that they believe complies with the court's rulings on December 3rd, 2025. And they failed to follow the court rules to schedule a hearing and file a notice of hearing regarding their motions. I think they belatedly, after the court scheduled the hearing on its own, did eventually file a notice of hearing.
I advised them that they hadn't filed a notice of hearing. And then they said, well, what do we need to do? And I'm not sure, but I think then they tried to remedy it.
It's been my experience that when a party fails to set motions for hearing, fails to file a notice of hearing, and fails to file an alternative proposed order to the order they're objecting to, the court would not set a hearing date to the multiple, due to the multiple court violations. However, that is not the case in these cases. The history in these cases is that no matter what the orders file, no matter how many court rules are violated, the court sets hearings and Colon Township is required to defend. In addition to the above, the order's motion to strike includes an alleged quote from Tiedemann v. Tiedemann, 400 Mich, 571, 1971 to support their motion. The quote, and it is a quote in their motion to strike, does not exist in the Tiedemann case, and the subject of the quote isn't even a holding in the Tiedemann case. In short, the orders either intentionally or through gross negligence attempted to mislead this court. The order's motion to strike includes an alleged quote from a case they captioned In Re Estate of Temple Marital Trust, 278 Mishap 122, 2008 to support their motion. The case with the site of 278 Mishap 122 is actually captioned Temple v. Temple, and the quote in the order's motion does not exist in the case, and the subject of the quote is not even a holding in the Temple case. The order's motion to strike contains an alleged quote from an alleged case captioned Palazzolo versus Gorsica with an alleged site of 200 Mishap 27, page 271, 1993 case. I could not even find that case by searching the names or the site. In short, the orders and those persons assisting them believe that when this court holds a hearing on a motion and makes the rulings on that motion, the order entered by the court in regards to the hearing must mirror the transcript of the hearing word for word. I refer the court to page 7 of the order's motion to strike, where one of their relief for request states, direct plaintiff's counsel to submit a corrected order that mirrors the transcript word for word. As the court is aware, there is no court rule or statute that requires this, and to my knowledge, there is no Michigan court that would require this. If this were the case, then a transcript would be prepared after every hearing, and the judge presiding over the hearing would simply sign the transcript. After I filed and noticed for hearing my motion for sanctions, the orders filed an objection in response to request for sanctions, claiming there is no basis for sanctions. MCR 1.109E states, the signature of a person filing a document, whether or not represented by an attorney, constitutes a certification by the signer that, to the best of his knowledge, information, and belief, formed after reasonable inquiry, the document is well grounded in fact and is warranted by existing law or a good faith argument for the extension, modification, or reversal of existing law. I'm going to go out on a limb and say, I don't think the Yoders or whoever prepared these documents on their behalf ever read the cases they were citing. If they did, they have committed intentional fraud on this court. On behalf of Colon Township and its taxpayers, I'm requesting that this court enter the two orders I submitted that accurately reflect the court's rulings on December 3rd, 2025, and grant the township's motion for sanctions, ordering that the Yoders pay additional costs and attorney's fees to Colon Township in the total amount of $1,624.68, which is the actual cost that Colon Township and its taxpayers have incurred in these matters since December 3rd, 2026. I would propose that that amount of $1,624.68 be divided between each case, since the motions were duplicated in each case. That half amount would be $812.34 in each case. Thank you.
All right, Mr. and Mrs. Yoder. The two orders that were presented, as Mr. Thornton stated, are brief, concise, and consistent with what the court ordered on December 3rd. They're asking for sanctions. We cited the rule. The person signing, for one thing, you're never very good on the procedural stuff. Getting notices, filing notices, getting dates, serving the other party. And he objects to my setting these things without you doing it right. Judge Stutzman might have just bounced it, but I wanted to get it to the next step, which is where we are now. But I would like to, at some point, have closure to this. You do have a right to appeal this. This is a circuit court case, so the appeal would be to the Michigan Court of Appeals. In a district court case, the appeal is to circuit court. This is a circuit court case, and the next level of appeal would be the Court of Appeals, and those procedural rules can be very difficult. So you filed your pleading stating your position. Mr. Thornton filed his responsive brief stating his. He's asked for sanctions, saying that you filed false pleadings. There's no merit to the pleadings that you did file, opposing these orders, which in my view are consistent with what I ordered on the record. So he's asked me to order you to pay $1,624.68 divided between each case. You did file a document called Objection to Sanctions. Let me take a look at that. Sanctions are not warranted under 1.109E, as he cited. Defendants were expressly authorized to file their motions and objections. Plaintiff does not deny the or factual issue accuracy of the proposed order. Yes, they do. the plaintiff does deny the accuracy of your contention that the order was not correct. Alleged citation errors do not support sanctions. Whoever's filing these pleadings, if they were an attorney, they could be subject to sanction from the Bar Grievance Commission. But these people aren't attorneys. There's not a crime. There are sanctions that can be done for practicing law without a license, but so you filed your responsive brief with your assistance. And is there anything else you wish to say regarding?
I guess our motions basically speak for themselves.
They do. They're
And I
written.
object to what he just got done saying, and I would like to have the objection noted for the record.
It is.
I say the order that he filed was very misleading. And the reason I say that is it doesn't have to mirror exactly what the court said, but I have the court transcripts for that day. And if you add or delete a couple of words, it will change the meaning of the whole thing. And that's why I say the order is misleading.
Well, here's what it ordered in each case. The defendant's motion identified above are denied in their entirety. And I denied all your motions. The order following hearing held on December 15th and entered November 5th shall stand as ordered. That's what I ordered. The restitution ordered in paragraph 1 of the order following the hearing on 10/15 shall be paid on or before January 2nd. No additional costs are ordered. That's what I ordered. There's nothing untoward or misleading about those. Defendant's motions identified and denied in their entirety. The defendant's order, the court's order held on October 15th, entered November 5th, shall stand as ordered. I'm going to sign the order in each case. Today is the 23rd of January.
2 months old.
In file 25040CZ. Again, restitution ordered in that case shall be paid on or before January 2nd. That's not plausible. I'll make it due by 21 days from today. Today is the 23rd
And Lance said that they couldn't even find that one case
Yes.
that we had listed. Well, I guess that's amazing that an attorney can't find it, but a dumb Amishman can find it.
That case would be
Right, there it is.
Palazzolo versus Gorsica.
To the best of my knowledge, I did not file anything that did not match with the paperwork.
Yes, that's to the best of your knowledge. Somebody's leading you down the pea path by doing bad lawyering.
But I guess the court order that I got had more writing in it than what you just read. I was gonna bring that order along and I didn't, I forgot it.
These are the two proposed orders that were objected to. Is that correct, Mr.
Well, the
Thorne?
court order that I got, it's got more writing in it than that.
I can state for the record, the order I sent to them under the notice of presentment was the exact same orders that were submitted to this court.
And it says more than what he just read.
Well, the ones I'm about to enter say exactly what I said.
And I guess if you look up sanctions and the rules and regulations for sanctions, sanctions require filings not grounded in fact or law. These filings are expressly authorized by the Michigan court rules.
There is no Palazzolo versus Corsica under that citation. David Corsica was the Oakland County prosecutor at that time. He was a friend of mine.
And there was one other one. Show cause motion cites MCR 2.114E, which is a court rule that has been deleted since 2018. I guess I read that one. I checked even on that one. The rule was moved to MCR 1.109 effective 9/1/2018 and is still in effect under that rule.
Defendants' motions objecting to the entry of the order are briefed and preserved, and their objections are preserved. Those motions are denied, and the order shall enter as ordered by the court on December 3rd. The motion for sanctions is granted. The court will apply $812.34 per case. The others are due by February 21st. Those are also due by February 21st.
Your Honor,
yes.
In order to try and avoid this whole situation again, I've drafted and prepared orders that you could look at right now if you wish to.
Yes, I would.
That would prevent me from having to submit it under the 7-day rule, objections, and another hearing.
You have a right to appeal this. You have moved your birthing center, as far as I can tell, from that location. There is a need or demand or for your service. Just couldn't do it there.
Those are identical orders, Your Honor.
All right, let's review it. Did you give them a copy?
I didn't.
Do you have one for them? I don't. Or would you make copies for the defendants? All along while we enter them. I'm just trying to get the orders entered and finalized. If you wish to appeal it, you have that right. The appeal, as I said, would be to the Court of Appeals. The effects of the orders have mostly been accomplished. So we'll see where this goes. So these will be final orders that you can use to appeal my ruling. And I know you disagree with it. That's your right. The other stuff is just static. The orders are brief. They're straightforward. I believe they comply with what I ordered. I'm not sure what you're referring to as change a word here or there. Those orders are quite brief. And
well, like I said, the one that I've got had something in with motion with fraud was denied. I forget what all it was, but there was a lot more stuff than just what he read.
Defendant's motion to strike proposed order, and these are parallel. One is in 25040 CZ, one is in 25533 CZ. Paragraph 1, the defendant's motion to strike the proposed order of December 4th filed with the court on December 10th is denied. Defendant's motion for order to show cause filed with the court on December 10th is denied. Defendant's objection to entry of proposed order filed with the court on December 10th is have been found to have been filed by the defendant without legitimate basis for filing an objection. Plaintiff's motion for sanctions dated January 12th is granted on the basis that the defendant's motions and objections were signed in violation of MCR 1.109E. Shall pay to the plaintiff. They've got 30 days in here, and I'll leave it $812.34 in each file.
What was the amount to put in there?
$812.34. If you double it, it's $1,624.68. That order is signed in file 25040 and in 25533 CZ. I hope this brings closure to the circuit court. Activity in this file. If it goes to the Court of Appeals, that's outside my province. They can review it. All of these issues have been preserved by your pleadings. So there are 4 orders entered today. The original order following the hearing that was submitted under 7-day rule that you objected to. In file 25040 and 25533. Then I filed 2 additional orders, again in each file following this hearing. So you owe the restitution in the original case by December 15th, and you owe an additional $1,624.68. If you object to it, appeal it to the Court of Appeals. They have jurisdiction to overturn my ruling. They may view the matter differently than I did, but any further pleadings in this court could be met by further financial sanctions. All right. We'll get you copies of each of those orders. And we'll go take these up and file them with the clerk. And we'll get copies right now for the orders while they're here. All right, Mr. Thornton, thank you for the original orders and thank you for preparing those additional orders for today. You're welcome. All right, we'll be in recess. I hope this concludes this matter. Everybody needs to go next. And the jurors are back in the jury room. So we may have some other people coming in and out of here. We may hear some voices in the back. Oops. Well, it's good afternoon here, so we'll get right to business. Good afternoon, everyone. Oh, would you give this to the defendants? This was left on the table after your last hearing. I didn't look at it, but I kept it to return it to you. We've got two matters to address this afternoon. File 25040CZ is entitled Colon Township versus Alfred Yoder and Joanne Yoder. We had a hearing on September 24th, and the court made some rulings. Mr. Thornton submitted an order. Frankly, Mr. Thornton, I don't know what happened to it. The circuit court filing things are a mystery to me. We had trouble finding things today. We were looking for, I know you'd filed an affidavit of cost, but I couldn't find it. We did finally find it. Anyway, I got this order. It's not date stamped. But you filed it shortly after the hearing, I think maybe on the 30th. We'll address that in a minute.
It's on September 30th.
All right. It's not date stamped, but we think we discerned that. All right, that's an order following the civil contempt hearing in 25040CZ. That's what we'll refer to as the birthing center. In the adjacent building that was subject to a stop work order, that is filed 25533CZ. I entered a permanent injunction on that day. I wrote the 23rd, but it was the 24th. In that case, the defendants filed some last minute briefs in that matter shortly before the hearing. I think they were bench filed on that day, and they weren't addressed. And I said I would address those hearings today. Mr. Thornton has filed a responsive brief. Then yesterday, I saw the defendant's associate here at the courthouse, and we said hello. And I surmised that she was here at the 11th hour filing some filings again. And they never told me, so I called the clerk's office this morning to say, did they file something yesterday? And after some searching, I was advised that they did. So they filed more things effective yesterday in the 040 case and the 25533 case. So let's set aside the adjacent structure 25533 for a moment. We'll come back to that. I'm going to sign the order that I should have signed a month ago or weeks ago. I'm going to sign it effective 15th of October, granting the relief I ordered on the 24th. Would you please make 2 copies of this, one for Mr. Thornton, one for the defendants? All right. We've got a couple orders of business, and it's hard to try to keep everything straight. After I made my rulings on the 24th, the permanent injunction default that had entered remained in place. Mr. Thornton requested a fine of $3,500 per defendant and cost for the township. He was true to his word, and he filed an affidavit of costs, setting forth the cost that his office and the township had put into this matter. We'll address that in a minute. On October 6th, the Yoders filed a filing package for the October 15th hearing. And the problem is it mixes the 2 cases together. It's got 25040 and 25533 penciled in. So the 40 case has just to do with the birthing center. One of the documents here actually does have some relevance. Motion for reduction or remission of fines. This court has scheduled a hearing to determine the contempt fines. That statute authorizes the court to mitigate or discharge any fine where a party has purged the contempt and complied with the order. Defendants have ceased construction and abandoning the birthing center units and now seek lawful residential permits. Continuing to impose large fines serves no remedial purpose, will be punitive and excessive. Defendants ask this court to exercise its discretion to reduce or remit all civil fines and close the contempt matter. That's the most relevant pleading I've actually seen in all the pleadings. So Mr. Thornton requested a substantial fine and costs. As we know, you've each posted a $1,000 cash bond with the circuit court for failing to appear for one of the hearings. Judge Stutzman ordered a bench warrant with the bonds, and you posted the bonds, and the matter was continued, and I've been holding those bonds since. So the first thing we're going to do is address the issue of the fines and the costs. I'll hear from Mr. Thornton first, and then I'll give you a chance to respond. That pleading actually was pretty good. The law is different in zoning matters. In most cases, most criminal cases, if you're charged with a crime, you don't generally have to pay the cost of the prosecution. There are some exceptions that specifically allow for the cost of prosecution. And if you were charged, for example, with driving suspended under Sturgis City Ordinance or 3 River City Ordinance, and they had a trial, and the prosecutor spent $2,000 preparing for the trial, you don't have to pay for that. They don't get to ask for costs of somebody having a trial in the matter. People have a right to have a trial in the matter. So they shouldn't have to pay a premium for it. As I indicated, there's a couple of statutes, drinking, driving, and some others, which allow the court to order the cost of prosecution, but it's very rare. However, in zoning matters, the cities and villages and townships will often ask for their costs. To do zoning enforcement costs all the people in the township. So Mr. Thornton has asked for a fine, and he's asked for costs. So Mr. Thornton, at the close of the last hearing, you asked for a substantial fine as to each defendant. Would you like to speak to that?
Sure, Your Honor. The statute for contempt, the section 600.1715 is one that addresses the fines and allows for up to $7,500 per defendant. So in my discussions with township officials, we came up with the request for $3,500 for each defendant for a total of $7,500. As far as the fines, the
3,500 times 2 equals 7,000.
7,000, sorry. But that is correct. 3,500 each times 2 for the 7,000 total. The township's restitution request is based on 600.1721, payment of damages essentially caused by the contempt that the defendants have found to have committed against the court orders. And that's, as I read it, mandatory. The court shall order the defendant to pay such person a sufficient sum to indemnify him. When I submitted the affidavit of costs, it only sets forth costs that I believe relate directly to the civil contempts and the additional costs that the township incurred because of the civil contempts and the failures to appear. So that even though it's a substantial amount, that of in the affidavit of cost of $3,885.50, that certainly does not even come close to what the township has spent in case 040 to get it to where it's at today. So I leave it up to the court. It is the court's discretion on the fine. But I do request the restitution to the township as to the affidavit of costs, and in addition to the motion, let's see, the taxable costs that were incurred, all set forth in the affidavit of costs. So it so as I calculate those, there's $3,994.46, all accounted for in the affidavit of costs. There is $265.48 in the cost ordered in the default judgment in case 040. And I'm requesting an additional $190 in cost for responding to defendant's filing package in case number 040. And I believe that's the recent one Your Honor was mentioning.
The October 6th one are the ones we got yesterday.
No, that doesn't, the October 6th ones.
All right, so is that 190 in your bill of costs?
It's not, Your Honor, because it came in.
You did put in an hour estimated for today.
For today's hearing,
All
but
right.
that 190 is just responding to that motion on October, that what they call a filing package.
Yes.
On October 6th. And there was one filed in each case, and that's just for the 040 case. So that totals for 040 case, $4,449.94.
All right. Thank you. I knew you had prepared it. I had a heck of a time finding it, but we did find it. It was date stamped the 30th. I don't know how they do things in circuit court. When a motion is filed in my court, I'm given a copy of it. They just, maybe it's because I'm a district judge by assignment, it just gets stuck in an electronic file. The original is destroyed, although I was managed to save the originals from yesterday. And then it just goes in the file and they don't say, hey, this got filed, or I guess, I don't know if he looks in every file every day to see what got filed, but anyway, it's a system that's different than the one I'm familiar with, but I knew these things were out there. All right, Mr. and Mrs. Yoder, I tend to agree with you that you are in compliance with what was originally ordered. You don't necessarily like it, but you've accepted the inevitable. You've ceased to operate the birthing center, at least at that location, and you stopped construction on the adjacent building on the lot next door. We're going to talk about that case in a minute. And to assess a large fine of $7,000 on you and your family seems to me to be overly punitive. And as Mr. Thornton mentioned last time, the township doesn't get the fine. It goes to the court and to the state of Michigan, and the court has discretion in the fines. As he indicated, the statute doesn't give so much discretion regarding these taxable costs. The statute says the judge shall assess those costs. That's 600.1721. So I don't have a lot of discretion. Mr. Thornton has a billable rate which is lower than many attorneys, certainly in a larger city. This was a Detroit law firm, or even Kalamazoo or Grand Rapids. That hourly rate would be substantially higher. And truth be told, he probably has more hours into it than is on the billing. Also, this is only his cost as to the contempt portion. The matter was set for hearing in front of Judge Stutzman. You didn't show up. There was a show cause. You didn't show up. A bench warrant issued. And then sometime after the bench warrant issued, Judge Stutzman asked to recuse himself and asked me if I would take it. So this train was quite a ways down the track before I got on it. But I'm going to grant a cost as assessed by Mr. Thornton in his bill of costs. But before I do that, I guess I gotta give you an opportunity to be heard on that. I'm not going to assess any fine, but he's filed an affidavit of costs. And do you wish to respond to that?
Negative.
All right.
Yeah,
Yes?
so, I object because we are already complying to good cause. So why should we be punished with a fine?
Well, I don't necessarily disagree with that. So I'm not giving you a fine. They asked for $3,500 apiece, and you are in compliance. So I'm not ordering any fine. What I am ordering is that you pay the cost of what the township had to pay for your failure to appear and all the contempt rigmarole that we went through. As I said, that one was well pled. So I'm granting plaintiff's request. It's in the bill of costs for attorney fees of $3,885.50 plus $190 for responding to the October 6th motion. Plus taxable costs of $108.86 plus the earlier costs of $265.48. If we add all that up, it adds up to $4,449.94, offset by the $2,000 bond. Which leaves $2,449.94 due within 30 days. That is just cost. There's no fine. All right.
I did prepare an order, Your Honor, but I'm not sure. It doesn't really take into consideration the 2,000 from the bonds. But I don't know if Your Honor wants to review it and mark it up. Or...
Yes, let's try it.
Two paragraphs on restitution, one for each defendant, and two paragraphs on fines, one for each defendant. Obviously, under the court's ruling, the fines would be 0. And then I'd set it up so the restitution would be divided between the two defendants, since there are 2 defendants.
Well, I'm going to do it joint and severally. 2,449.94. The total amount is 2,449.94. It's not twice that. And you're jointly and severally liable for it. If Alfred pays the whole thing, that satisfies Joanne's obligation. If Joanne pays the whole thing, it satisfies Alfred's obligation. If you each pay half, it satisfies your obligation. So the total amount is attorney fees, the previous court costs, and the related costs, jointly and severally. They don't get to collect it twice.
Your Honor, is the order reflecting that the $2,000 bond is also going to be forwarded to the
Yes,
township?
thank you. $2,000 cash bond. 1,000 per defendant. Well, it's already been applied. Was applied. To total of 4,449.94, 449.94. So the total, I'm going to change that. 4,000. Maybe clean this up. 4,449 less $2,000 cash bond. So each defendant owes 2,449 jointly and separately. All right.
So does the order reflect, and the clerk's office will know to forward that $2,000 bond to the township?
Shall be forwarded to township. Thank you. That's a little bit more clear for them. All right, so that's the issue regarding costs and fines in the birthing center case. Defendants filed some last-minute motions just before the hearing and filed more motions yesterday. Mr. Thornton filed a response to the filing package filed October 6th. He filed that the very next day on October 7th. One of the problems is the thing had both case numbers on it. So it was hard to discern it, but you're asking to modify or clarify the permanent injunction. I didn't really understand all of it. Equity and change circumstances, statutory authority, due process of public authority concerns religious and cultural context. I had already determined that Judge Stutzman's default order would stand because the defendants had failed to move to set the default aside in a timely manner. Then after we have that hearing, they filed this on October 6th. Mr. Thornton objects to that on multiple grounds. So Mr. and Mrs. Yoder, we've got your October 6th motion and we've got your new motion filed yesterday. Motion and brief to recognize compliance, set aside default judgment, and for equitable relief. I'd said this several times. Yes?
That one that was filed yesterday?
Yes.
Was filed yesterday because we got Lance's love letter Saturday and nothing was open Monday, so we had to wait till yesterday to file it. That's why it was filed last minute.
All right, well, I'm not aware of any letter, love or otherwise, from Mr. Thornton, but trying to be diplomatic here. I said from the outset that I first got in this case that you needed a lawyer. At one point, apparently you had one, Mr. Marvin, and I don't know, that didn't go very far. I'm not sure what happened. You got advice from people that aren't lawyers. And in essence, they're practicing law without a license. And most of the advice they gave you was bad. You ended up almost going to jail because you took advice of people that don't know what they're talking about. You got bench warrants issued for me from Judge Stutzman. You may well have had some defenses to these matters. My sense of you folks is that you're honest, hardworking, Christian people that wanted to provide a service that people want. There is demand for your birthing center, and you have a great community support for that effort. But you can't do it where it is. This wasn't my idea. This is how it came up. In fact, I'm still dumbfounded that there's not some sort of state licensing or something for such a facility, but that never came up. That you just wanted to do your work and have everybody leave you alone. And frankly, most people probably feel that way. But you can't do what you were doing where you were doing it. Judge Stutzman had made a finding of default and he entered that order. So I was operating from that order, but they heard maybe some testimony about problem births or other things I don't know. My son would have died if he was at your birthing center. He was an emergency C-section and they called Dr. Don in the middle of the night. He came to Three Rivers and did a C-section on my wife because he was a frank breech. Those are decisions I don't have to deal with because this judgment already entered. So people want you to provide this service, and maybe it can be somewhere that's close to other hospitals or facilities if there is an emergency. But all this stuff that gets filed at the last minute, the day before the hearing, it's not captioned properly, it's not signed properly, it cites stuff that isn't legal authority. You've been taken advantage of by people that are well-meaning, but they don't understand what they're doing. It's to your detriment. So you filed these motions. All right, first, let's talk about the October 6th motion. Yes, Mrs. Yoder?
So when we was here to meet you first, you gave us the rights, I've wrote a note here for me. You had said that we can respond in any way, handwritten or anything, where are we being judged and how we respond?
Yes, you can. It isn't very effective. You're sincere about it, but you don't, the law is complicated. And you're all here witnessing that. It's complicated, it's cumbersome, it's expensive. And you're doing the best you can, but your responses don't comply with the court rules and don't constitute a defense to the township's action. I'll repeat myself for about the 10th time. Judge Stutzman ordered a default judgment. You didn't show up for the hearing. They had a show cause hearing. You didn't show up for that. Bench warrants issued for your arrest. So that order was already issued. Now you're asking me to set aside the default on October 6th, and you're asking me to set aside the default again on October 14th. That ship has sailed. So maybe I don't understand your pleadings well. In fact, I'm not sure you understand them well. But let's talk about the October 6th pleading. What are you asking me to do?
Let me finish my building.
Yeah, well, we're gonna get to that one in a minute. That one, that's legit. That looks like a nice, well-built building that could have a purpose. Right now, we're just dealing with the birthing center case. We haven't gotten to the building case, but I went out and looked at it, and it looks like a nice building, and it could be something that you could utilize. You've got tens of thousands of dollars into it in material alone. So we'll see if we can come to an answer to that question. But right now we're in the other case. When I got this, I thought, well, I'm going to have to follow this to the end. And we got to figure out what to do with that other building. And we'll try to address that here in a minute. All right, Mr. Thornton, any further response to the October 6th filings?
Yeah, Your Honor, in reviewing all this, and it gets confusing for me too to deal with all the filings, but to my knowledge, in the 040 case, there was not one motion set for today for hearing. There was no notice of hearing ever served upon me and my office. To my knowledge, there was never even scheduled.
Well, I had scheduled the last minute motions in the
533.
In the 533 for today. Yes, okay, so
I agree with that.
This one says 040, but it wasn't noticed for anything.
Correct.
All right.
And I guess what I'll state is the Yoders are arguing that they've complied. I'm not sure that's clear at this point in the 040 case. And one of my responses, I did make the court aware that the babies are now being born on Mountain Road, and then mom and baby are transported to 30100 Marsh Road, Yoder's property. It's the subject of the 040 case for.
I object to that one.
Well, that's not testimony, so I guess you can't object.
And this is based upon information and belief, information I'm getting out of the clerk's office from birth certificates being filed there, and secondhand information that the township's getting from witnesses. So
where are they being born now?
Mountain Road, in a home on Mountain Road.
Is that in Cowan Township?
It is. And then the information we're getting is they're transported over to the birthing center and for aftercare and a stay there until they're ready to leave.
Well, I don't know the answer to that one. I don't know. Maybe we aren't done with this case. I had hoped that we were.
I'm not asking the court to address that. I realize that's going to have to be addressed in the future. But the orders are basically arguing that we've complied in 040 case, and therefore the whole default judgment, permanent injunction should go away. And there is just no legal basis for that argument that we complied, therefore the judgment and permanent injunction should go away. Certainly, as they have done, and the court has recognized that was an argument for reduction or waiving of the fines, but not to set aside, as they've requested, the default judgment.
All right, I have heard their plea in the motion for reduction or remission of fines, which essentially I granted in full. The motion to set aside the default from the October 6th motion is denied.
Your Honor,
Yes.
I object to that. September 24th, we were asked to give no care to pregnant women at 30100 under lots of stress. We have faithfully followed the court order. It is heartbreaking that our elected township has become so distressful that a simple family gathering or visit from friends and relatives are treated as a violation. We have a pregnant daughter and pregnant daughter-in-law who cannot even come to our property without being stalked or accused of breaking the law. This is not justice. This is prejudice. We hope these watching and listening today will see that we are peaceful people trying to do what is right. Please help us restore the fairness and stop this unlawful behavior by township. We have shown good faith and asked for good faith in return. We've done everything the township has asked. We're compliant, we're peaceful, and yet we're still treated like offenders. This is not how community or justice should work.
Well, thank you for that. I haven't found that you've done anything else in violation. What you just told me is all news to me, just like what Mr. Thornton represented. You certainly should be able to have your family members come to your property, but that's not before me. I'm not finding that you violated anything else. At this point, I'm taking you at your word that you've stopped using this as a birthing center. So that October 6th motion is denied. Yesterday, and this is one I had to track down. I saw your associate here and she was cordial, and she had something in her hand, and I thought, well, did she file more stuff? And it took me till about 10:30 this morning to actually get it. But this one is entitled, it's in 25040. It's entitled Motion and Brief to Recognize Compliance, Set Aside Default Judgment, and for Equitable Relief. Regarding the October 14th motion, the one that was filed yesterday, and you said you got some sort of letter from Mr. Thornton on Saturday. Don't know about that, but what are you asking me to do in yesterday's motion?
What can we do with that building?
Well, that's in 535. What can you do with the birthing center?
The Mama's house building. Because as it stands right now, the way I understand land, you can't do anything in that building.
Well,
We've got our belongings in there. I mean, it's freezing.
well, you can, I don't know the answer to that. I don't know if there's more than one structure on that property. There's a house and maybe an adjacent house and then the birthing center. And I don't know the answer to that. Can you reside in it? Can you have a prayer meeting in there? Can you?
Well, prayer meeting wouldn't be allowed by Colton Township.
Your Honor, can I address that?
Yeah, I guess so.
The township's position has never been, and we've never told the Yoders that they can't use 30100 as a residence. That's what it's built as. That's what it was designed for. And they can certainly continue to use it as a residence. Colon Township zoning ordinance allows 2 residences on 1 parcel. So the Yoder's home at 30158 and the Mama's house, current, what was used as the birthing center, 30100, are on the same parcel. So they can use both as residences. Township's never taken the position that they cannot use both homes as residences. But the court order is very clear, and the default judgment, permanent injunction are clear that they can't use 30100 as a birthing center. So different from a residence. So I'm not sure where all this is coming from, that they can't do anything with 30100. It can be used as a residence.
Well, all right, fair enough. That answers that question. And again, it's too late to set aside the default. You're asking for equitable relief. Equity permits relief from judgment if it would be unjust, inequitable, or contrary to the public interest. Again, this order has already entered by default, and the defendant didn't move to set aside the default in a timely manner. So if there was no injunction and you were living there and your daughter and son-in-law lived there, or whoever lived there, that's completely within the recognized use in Colon Township. And the things that you can do in your own house: host Christmas, have a prayer meeting, have your grandkids over for the weekend, the kind of things anybody does in their own house. Those you can do. You can't operate it as a birthing center. So the motion for equitable relief and set aside the default are denied.
Yeah,
Yes.
I just want to clarify the situation on it as far as the 30100, because the way I understood in the last hearing, that it was made very, very plain that absolutely nothing to do with pregnant women. And
Well,
that's why I was very concerned about.
Well, let's take a look at Judge Stutzman's order. Default judgment and permanent injunction.
Actual order starts on page 3.
The above findings of fact are hereby incorporated and made a part of this judgment. Colon Township's request for adjunctive relief is granted, and the defendants shall cease operation of the birthing center on the Yoder property as soon as reasonably possible. I think we settled on September 1st or 3rd. Defendants and their agents, service, assigns, and successors in interest, or anyone in active concert with participation with the Yoders with regard to operation of a birthing center, are permanently enjoined from operating a birthing center on the Yoder property. Colon Township shall cause a certified copy of this judgment to be recorded with the officer of the Register of Deeds within 30 days of the date of this entry. No money damages awarded to Colon Township. Defendants are ordered to pay $265.48 in taxable costs. All right. you raise a legitimate question. There's no definition in here of what is a birthing center. The presumption is a birthing center is a place where people go to release their confinement and give birth to a child. If the children are born somewhere else and then come there, not sure what that is. That's a daycare center, but the birthing center is not defined. So your request for clarification probably has some merit to it. The order doesn't define it. I don't know that it did otherwise, but a birthing center, let's take it at its plain meaning. It's a place where people come to give birth. And you have a large following, you have more births of that birthing center than probably both Three Rivers hospitals combined, Three Rivers and Sturgis Hospital combined. More babies were born in St. Joseph County at your birthing center than anywhere else. Most of the babies here are going to South Bend or Elkhart or Kalamazoo, Coldwater maybe. So you can't have births there. Can you have children and mothers come there after they give birth? I don't know the answer to that. The township, if you do that, the township is going to ask for further relief. My hope was you could find a place to put this that would comply with zoning, either in Colon Township, in LaGrange County, in some other township, and then continue to provide your service. Frankly, that's what I hope. You've got people that want to use the service, you want to provide it, but you can't do it here. This just keeps poking at the sore point. So all I can tell you is what the order says. And you're not to operate a birthing center on that property. Mr. Yoder?
We are looking into buying other property in a township that's got a little more brains.
All right, well, I don't, like I said, there's a demand for your service.
Well, it's obviously, yeah.
So that would, that's what I hope happens. I hope you find a place to put this where it can be licensed and everybody's in agreement and you continue to provide a service that people want.
We have 2 townships that are begging for us to come their way.
All right, well, more power to you. All right, so that resolves the 2040 case. The injunction remains in place. You're not to operate as a birthing center. I've ordered costs as they requested with Mr. Thornton's bill of costs. I've denied your motion of October 6th to set aside the default. I denied your motion of October 14th to set aside the default. So as far as I'm concerned, that case is done once you pay the balance of the costs. And that number is $2,449.94. Mr. Thornton, would you do an order denying the defendant's requests of October 6th and October 14th?
I will, Your Honor.
All right, let's go to the adjacent property. In the 25539 CZ, I could tell that this was going to be a problem that would need some further attention. As I said, I went out and observed it. So I did an order on August 29th granting the preliminary injunction. Then on September 24th, I entered the default judgment granting the permanent injunction. And this had to do with a stop work order on that property. Now that order is dated, I wrote the 23rd of September, it was actually the 24th. Orders. The defendants, their officers, agents, service employees, assigns, and successors are permanently enjoined from performing any further work on the interior, exterior of the building being constructed on the subject property unless a valid building permit is issued for the building by the plaintiff's building code officials and stop work orders that have been issued and posted. Occupying the building, you're enjoined from occupying it or allowing anyone else to occupy it unless written authorization is obtained by the building code officials. That's commonly known as an occupancy permit. C, if an occupancy permit is granted for the building, using the building for anything other than a residential home for which zoning approval was obtained, this prohibits the use of the building by midwives and pregnant women as a place to give birth for compensation, including room rental fees. This does not prohibit a woman from choosing to have a home birth in the building if that building is that woman's principal or permanent residence. So if your daughter or daughter-in-law live there, they have a baby there, that's within their rights. All right, so right now there's a stop work order until it's approved by the zoning officer. And the township would grant permission to turn it into a residence because that's what it's zoned for. So that's the order that was in effect from September 24th. So you filed some motions immediately before that one that I didn't have time to address. So I set those for today. You bench filed on October 24th. Excuse me, September 24th. I'm not sure what this is called. Defendants respectfully move the court to dismiss the above captioned action for lack of jurisdiction, due process violations, and the township's failure to present a lawful case. This action is built entirely on defective proceedings where no proper sworn witnesses testified, no valid authority was demonstrated, and the attorney for the township improperly acted both as advocate and de facto witness. Again, a default entered. There was a temporary injunction that was then granted in full on September 24th. This is bench filed on September 24th, like 1 minute before the hearing. I didn't have time to address it. It's not signed. It isn't titled, but I guess I'll entitle as a motion to dismiss. Mr. Thornton filed an answer to that a few days later, objecting, arguing the motion is not signed. The motion does not need to meet the filing standards set forth in MCR 1.109D. The legal brief was not filed with the motion as required by law, and the defendants have not moved to set aside the default judgment entered in this matter. They simply asked me to dismiss it. While the motion appears to claim that the court lacked personal jurisdiction over the defendants and subject matter jurisdiction, Motion fails to set forth any facts or recognize legal argument to support a claim of lack of jurisdiction. Instead, the motion attempt to raise defenses to the township's claims set forth in his complaint that the defendants could have raised had they filed an answer and participated in deciding the merits of the township's claims. That happened in both cases. You got sued, the lawsuit was served on you, and you never filed a timely answer. So in each case, you got defaulted. And in each case, you didn't file a timely motion properly to set aside the default, where you have to state legitimate reason for not responding to the summons and complaint and file an affidavit of meritorious defense. On all of those matters, you could have been helped by an attorney that knew what they were doing. So Mr. Thornton asked me to strike the motion in its entirety due to the fact that it's unsigned, strike the motion entirety due to failure to comply with the court rules governing the motion, and deny the motion in its entirety.
Your Honor,
Yes,
which one are you talking about that we didn't sign?
this one, bench filed on September 24th. Let's see if it has a date on it.
I don't believe it does, Your Honor. It was undated and unsigned.
So I'm gonna strike that one. Plaintiff's request to strike that unsigned motion is granted. Mr. Thornton, I'll ask you to do that order too. Then this morning at 10:30, I got your newest pleadings. They were filed yesterday afternoon at some point. They're date stamped October 14th. And again, I had to go seek them out. It's titled Motion and Brief to Recognize Compliance, Set Aside Default Judgment, and for Equitable Relief. Now, there's also a brief in support of the motion to recognize compliance, set aside default, and equitable relief. This has to do with the adjacent house, which would make a very fine house, I guess, if we could turn it into a residential property. You're not the first person to be frustrated by dealing with zoning officials. Some are more strict than others. Some township zoning rules are stricter than others. And they're all stuck with the proper building, electrical, plumbing, mechanical codes that require things be done in a certain way. Those zoning officials are not elected officials. They don't swear an oath. They're hired as an independent contractor by the township to handle the zoning and construction code matters. So again, I didn't see this until this morning. I was busy with other stuff. I shut my door at 10:30 and tried to make sure I could digest all this. So I worked through the lunch. So it's your motion. Either Mr. or Mrs. Yoder, what do you want me to know about it, your motion and brief to recognize compliance, set aside default, and equitable relief? The one that was filed yesterday.
Or can we get the injunction or whatever lifted and get the building permit so we can, maybe I can at least live in a mansion if I can't use it for anything else?
I'd like.
I mean, it's already zoned residential.
Yes, I'd like that.
Well, I applied for a building permit already like the 6th. And according to Lance, Safebuild is trying to work with us, something about the permit, but they've never called me and never sent me any letters or anything. I called twice and nobody answered, but they're trying to work with me to get more information.
All right. Mr. Thornton, apparently what they're really seeking is to figure out how to bring this building into compliance.
There's absolutely nothing that needs to be done, in my opinion, to the default judgment and permanent injunction in this case, because as we went through a few minutes ago, it lays out what needs to be done. And the Yoders have taken the very first step to do that. I have confirmed with Safebuilt that the Yoders did get an application for a building permit and recently filled it out, as Mr. Yoder says. I believe, not sure if it was October 6th, but it was very recent, in the last few days, a week here. And that was filed with Safebuilt, and the fee paid. But they have not obtained a building permit. It's my understanding from my discussions with Safebuilt that the Yoders need to modify the plans, which were for a birthing center, to show that they're for a residential structure in order to get the building permit issued. So that's where my comments that, and I've directed Safebuilt to work with the Yoders, but I highly doubt they've had time to, if there are letters that have been sent, which I don't know if they have been or not, they may not have been received yet, but I know there's an issue with the building plans that need to be revised or added to, supplemented in order for that building permit to be issued. Once that is issued, then they'll have inspections, and if the inspections pass and it's approved, I would assume there'll be a certificate of occupancy granted for it to be used as a residence. And
it would make a very fine house. You call it a mansion, I don't know about that, but it looks like a very nice home. Now, homes get built all day everywhere here in St. Joe County. As tedious as our building and zoning codes are, could be worse. I read this week it takes about 7 years to get permitted to build a home or a building in California. So they stop building anything because they can't comply with all the code restrictions. So they don't have enough houses for the people that want to live there. So people become homeless and the prices go up to unaffordable rates. We don't want that. In the gubernatorial campaign, both candidates argued that they wanted to reduce restrictions and red tape so people can get things done commercially. Heaven forbid, if you're trying to do some commercial construction, can be very cumbersome to meet all the code requirements. But all day, every day, somebody's building a house here in St. Joe County. And many are Amish built houses, both in Colin Township and all over the place. They're some of the finest carpenters around. So they know how to do it. And they know how to do it to get it permitted. I don't know who drew your plan. It doesn't look like somebody just showed up and said, hey, look, let's put this building up. It looks like it had some sort of coherent plan. And there are all the other issues that go with it: plumbing, electrical, mechanical. I don't know if this township has radon abatement or other things that often go into construction, but somebody drew a plan. And somebody needs to redraw it to make this into a residence.
Your Honor,
Yes?
I don't see any necessity of redrawing it because this plan, I drew up the plan to make it suitable for my likings. And that is exactly how I want my house. I wouldn't change a wall. It is exactly what I want for me and my family.
All right. I don't know what the plan looks like.
It's my dream home.
Okay, then we need to get on the same page. And let's say it's a weird central kitchen area with 9 bedrooms off to the sides. If that's your dream home, I don't know. I don't know what it looks like on the inside. So at this point, you and Safe Built haven't really got down to the nitty-gritty. So you're saying you would live in this as a residence just as it's designed now? Is that yes?
Yes.
Well, the same thing. I'm gonna deny the motion to set aside the default. These defenses, I guess, could have been raised earlier. The equitable relief you want is just to be able to use this building for your purposes. And I don't have any objection to that. I don't know that I need to grant an order granting you equitable relief. The problem is I'm probably gonna have to continue to hear this to shepherd this project through. I would be delighted if Safe Built came out and said you could do this, this, and this. These are the electrical requirements, these are the plumbing requirements. The inspectors came out, approved it, and it was built. You could live in it, have your grandkids stay there, but it would be a residence. So I don't deny your motion for equitable relief, but I don't grant it either. Meaning, if you are meeting with Safe Built and you don't feel that they are giving you what you feel is fair and equitable, you can ask me to hear it in the context of this case. You can file a request for relief. But my hope is that you got builders that know what they're doing. You got plumbers that know what they're doing. You got electricians that know what they're doing. That we can get this built. Winter's coming. It has a tight roof on it, but it needs to get sealed up. So, Mr. Thornton, you represent that Safe Built is ready and willing to meet with the Yoders to try to make this into a residential property?
Sure. My understanding, Your Honor, is that the plans have to meet the building code for a residence. And that's what's holding up the process. Mr. Yoder, when he went up and filed the application, and I'm getting this secondhand, was very rude and not to the Safe Built personnel and wasn't interested in sticking around. He just filed it and left. So they're gonna, and I've instructed Safe Built to work with the Yoders and to communicate with the Yoders as to what they.
Sir.
Well, you object that he'd asked Safe Built to agree to work with you?
I walked in there, I had the application and the check, and she looked at it, and I said, I don't remember exactly what I said, something about a building permit application, and she looked at it and she said something about the check ain't got nothing to do with this or whatever, but she can just hold it with the permit until it gets approved or whatever. I said, no, I'll just take the check with me. And I left. I guess I don't understand what this rude crap is about.
You're gonna have to talk to each other.
If you wanna know what rude was, you should have heard the electrical inspector the first time he was out at our place.
Well, everybody is going to have to.
I object to that one.
All right, well, you can object, but you're gonna have to, you don't speak the same language. I don't speak electrical. I don't speak plumbing. I barely speak English, and sometimes I speak legal. But they've got certain, now, I don't know what this plan is. I don't know if it has 12 bedrooms and 1,800 square feet. You can't do something like that. And if it has 9 bedrooms and 1 bathroom, you can't do something like that. So they've got certain requirements from the state of Michigan regarding building codes on what needs to be done. So you need to try to do this within the confines of the Michigan building codes. And they need to work with you to try to get to that point. Yes, sir?
Right. So they had issued a building permit to start with
Yes.
as a residential house. So
Yes.
that floor plan is approved for a residential house.
That's an interesting point. They had at one point issued a building permit on that plan. What's your response to that?
Your Honor, my understanding of that is that the structure is over 3,500 square feet. And requires under the building code, when it's over 3,500 square feet, that the plans be drawn by an architect because of the size of the structure.
Oh, boy.
And approved by an architect. That's in the Michigan Building Code. So my understanding is Safe Built incorrectly initially approved those plans and then went back and asked for, pursuant to the code, architecturally approved plans. Those, after a very long delay, the Yoders did submit architecturally approved plans that were never approved because those architecturally approved plans did not meet certain code requirements, and a letter was sent, but nothing's ever been followed up with to correct what needs to be corrected in those plans.
Well, they need to do it, and there needs to be some accord, some flexibility to try to get here. Yes, sir?
Yeah, I like how you worded that. After a long period of time, we finally submitted our plans. Well, if you know anything about an architect,
yes,
you contact the guy about getting a building drawn up, you're gonna wait your turn.
Well, I've been there.
All right.
I'm
So
there
that's
now.
exactly what I waited on. Now, if you want to turn that table backwards, we submitted those architectural drawings in October.
Of 24.
Yes. No, 23. Supposedly, I mean, like the dummy I am, I had my architectural drawings in there, so I wait on the officer to let me know what's going to go on with it. From October till March. Finally, in March, I get a phone call that I owe them $2,833, I think it was, to have this drawing approved. That's the first I ever heard anything. The day that that check was cashed, the print was denied.
Same day.
Same day.
And
So
another-
that's sort of a waste of $2,800 and some
I
dollars.
think it's gonna get you to where you need to go. So nothing has happened on this since.
No, I
March?
dropped that part because it was red tape and you couldn't work with Safe Built, you couldn't work with plants. He's gonna stop everything. So,
Well, we need a different mindset. We need a mindset. No wonder you're frustrated.
Yeah.
Um,
There's one thing I would like to ask for.
Yes.
We just want to, no more questions, no more answering any questions. We want to reopen this case and help.
I'm not sure I understood that.
We just want to just be able to reopen the case and we're getting help.
All right, reopen the case to run a birthing center there?
no,
Reopen the case to build a house.
yeah.
Well, it's never exactly been all right.
No.
You can't run a birthing center in this structure.
No.
On that lot. You can turn it into a residential dwelling. And
The reason I'm just saying this is because there's never any ending meeting like with Safe Built in the township, because like, just like when they said that we need to get an architectural drawing. Okay, my point was if they missed that and they didn't make sure that we have an architecture drawing at the beginning when we filled out applications,
Yes.
they should have seen to that.
Yeah.
Square footage is on every permit we've
well,
got.
apparently they
Before
issued the
we
original permit in error.
So-
So, all right, so you went out and got an architectural drawing.
But that wasn't easy because an architectural drawing, architect wants to make a drawing before the building's there. That was tough, finding someone that's going to do it, and every one of them, they're like, this is the dumbest thing they've ever heard. Trying to draw up an architectural drawing with a building that's standing there. So
The
that was a
architect
big
looked at
problem.
our drawings and said, he sees no problem with them drawing. That's better than most contractors do.
And if you get an architect to make up a drawing, that is undeniable, and they denied it. A licensed
All right,
architectural
well, did
drawing.
they say why they denied it?
There's a list this long.
Okay, well, we have to work on that list.
That's stupidity.
Well, I don't know what it is, and I'm not ruling it right now, but, yeah, it's the horse got behind the cart and is trying to push it. The house got built before the drawing got done. They gave you permission to
I
build
would have
it.
never built it if they wouldn't have given me a permit.
All right, I accept that. So now we're in a mess. You don't want to let it just molder away. You want to turn it into a house.
Truly, that's what was
All
supposed
right,
to be
you may
decided.
have some sort of a claim for reliance based on the township's granting the original permit. Again, you could benefit from having a real lawyer that does zoning enforcement stuff. But I'm just trying to get this case to the finish line where they can accept it, you can accept it, you can live in it. You can operate your birthing center in a different jurisdiction. Colin Township can go on to their other affairs. So can you. So I've denied your motion to set aside the default. I did not grant or deny your motion for equitable relief. I hate to say this, but it's what the answer is. You and Safe Built need to work together to get to a solution to this problem. I don't know why it took them from October to March to look at your plan, but so there is a drawing. They've got some issues with it. It's been dropped since that point. You need to go back and try to address those issues. Mrs. Yoder?
And another thing that had been mentioned in the last hearing, also about inspection, about only the footer. So I guess we can argue that point too, because the electrical inspection was all everything was fine except one spot that there was one thing that we had to change. And well, that hasn't been changed. I don't think that has been changed
No, you
yet.
can't change it because he said we gotta put something in that does not even get made anymore. And if I would make it with the one that is there, it would be illegal. Now, I guess you explain that one.
And the electrical guy, he argued the point for 45 minutes that they, that he just, I say argued, he stood there and listened to him for like 45 minutes to being using bad language and putting down his work. But there was no other inspections done.
The electrical inspector and my boy were on the phone for over a half hour. And the inspector was cussing, dropping the F-bomb and everything. And my boy, he's lucky I wasn't on the phone because I would have lost it.
Yeah.
Finally, he calmed down enough to figure out exactly what he wanted. And actually, what he wanted was actually right above his head. If you would have just looked, it was right there.
All right.
May I make a comment and maybe a
Yes, I mean,
suggestion?
all this stuff is stuff I can't resolve here. Nobody's under oath. They're just expressing their frustrations. And as I said, they aren't the first person to express frustration with the building code enforcement officials. But what would you like me to know?
Well, first a comment. And I feel I have to put this on the record because, and it's been raised in other pleadings in the case. The Yoders are not innocent people here. They misrepresented what they were going to build to the township in the zoning application. These are all established facts in this case. They misrepresented what they were going to build. They represented it was going to be, first it was a single family home, then it was a 2-family home. It was never represented to be a birthing center. And when it became obvious it was going to be a birthing center, then everything shut down and the building permit, stop work orders were posted, and then they continued on building as a birthing center until this court entered the default judgment, the permanent injunction. They had no choice. Now they're going to go back to use it as a residence. That's fine. That's allowed under the zoning ordinance as a suggestion, but they're not innocent people here in this process. And my suggestion is, and I will instruct Safeville, we'll set up a meeting where Safeville building official will go out and meet on site. But in order to do that, I don't know if all the no trespass signs that are that long and posted by the road, and the threats of the intimidation and threats to anybody that goes out there, including Bruce Morris that has to serve documents on the owners. He gets threatened when he goes out there. And so that has to stop. And if that does stop and the no trespassing sign come down, I'll recommend that Safeville go out there, meet with them, and let's figure out what needs to be done to get the building permit issued for the residents.
Well, I agree with that 100%.
I'll comment on that.
Well, just a minute. You and Safeville need to meet to figure out what needs to be done to get your permit.
But he said we misrepresented the whole thing to start with. Listen, I had 2 acres of woods behind my barn. All right. My wife told me what she got. She said they need more room. So she called Joe. I said, I'm not cutting any of my trees until I know that building can be built there. So she called Joe from Safeville, told him what we want to do. And he says, build it as a 2-family house. The contractor that drew the building permit made the mistake and put a 1-family resident instead of a 2-family house. That's why there's a 1-family house on there.
That was just one, he came to us and he said that I'm sorry, but I made a mistake. He found his mistake. He said that one of the applications I put down as a 1-family house. And I said, well, we're not holding it against him. I mean, we can make mistakes. We put a wall in the wrong spot, move it, put it.
So you want it as a 2-family residence?
We wanted to start with.
That's what Joe told us.
House.
All right, well, I'm not sure what you want now, but there should be a way to do it. There should be a way for you and Safeville to meet, and Safeville will say, all right, this, we need to change this, or this is fine, and come up with enough of an accord that you can get a building permit, build it, and get an occupancy permit.
The reason for him to say for a 2-family house, the reason that came in is because of what I'm doing. I wanted more space for myself. And so I wanted to design it. I have space for myself, but also have space for my moms. And so I told him what we're doing, and I need more space for both ways. That's why we're going with a bigger building, a new building. And he said, well, you would on most average have one family there with, or one mom with you, so call it a two-family house.
All right,
That's
so
why I was
right
putting
off
out
the bat, you told them this was gonna be an
Exactly.
extension of your birthing
I
center.
wanted a house. I don't want a hospital. It's not medical. It's absolutely it's nothing to do with medical. I want a house so people want a home birth, a home atmosphere. So that is where we have it as a two-family house. My belongings, my things, my space, and a space for them.
All right, well, you can't do that, at least not here.
Well,
You
we
can-
realize that part
All right,
now,
okay.
but like the thing, the
All
part
right.
what we're trying to explain is, he's saying that we misrepresented the whole thing. Well, I said, I'm not cutting any trees
All right,
until
I
I
got, yeah,
have
and I
all
got
my
what she said
permits.
too. She's, so some of that doesn't matter what happened in the past, because we're all stuck with it.
But he said we
All right, well,
misrepresented
so
it.
your position is we were upfront about it. I don't know. But Judge Stutzman ordered, then I ordered in the permanent injunction that you can't do it. So you want to turn it into a residence. You can do that. So let's figure out how to do it.
Exactly.
All right, you have to allow Safe Built onto the property to meet with you and your builder to say, all right, here's what we need to do. The outside is done substantially. The inside needs to get done. So that's just what needs to happen. You, your builder, and Safe Built need to meet on the site, not for fear of trespassing or execution or whatever. They can come to your property, meet with you and your builder and say, all right, let's do this, this, and this. You can't do this, you can't do this. Come up with a plan you can both accept and turn it into a residence. Saying it is easier than doing it. But to recap, again, Mr. Thorne, if you would do a motion denying the motion to set aside the default. I have not made a ruling on the request for equitable relief. I guess I would have put in the order. The Yoders are directed to facilitate and allow meeting the Safe Built on the property to try to come up with an acceptable building plan.
We can invite them.
Yes. And who's your builder?
I'm the builder.
All right.
So the only thing I've got though is, I don't care if Safe Built wants to come out and inspect, but sitting on the road, taking videos, sitting on the road, spying, that's, no.
Well, I guess at this point,
I've had that happen. I've seen it happen. He was seen videoing my wife.
Well, I don't even know what to say. Again, I can't change anything that's already happened. I would like to bring closure to this. I'd like you to find a place where you can continue your birthing, what you call ministry, where it's accepted. More power to you. I'd like you to be able to utilize this property as a dwelling, and everybody can go on with other matters. Yes.
So, Your Honor, before you close the case, so how does this work? Can you explain it to me? How does this work? So we get a lawyer and we,
well, at this point, I'm not recommending that you go out and hire a lawyer right now. I would have recommended you hire one at the start. The ship is almost in the harbor. The birthing center has been enjoined. The birthing center has been enjoined from the adjacent property. Now we're simply trying to turn that adjacent property into a dwelling with an acceptable building permit and ultimately an occupancy permit. I don't think you need a lawyer for that. However, if you get into the process and you feel you're being unfairly treated by Safe Built, at that point you could use the benefits of an attorney who does this sort of thing. And there's 16 townships and 8 municipalities in St. Joe County. That adds up to 24. And I'm the judge for all 24 of them. And so I get things from Sherman Township and Fabius Township and Lockport Township and Mendon Township and City of Three Rivers, City of Sturgis, and the rules aren't all exactly the same. What is substantially the same is the Michigan Building Code, which is based on a national building code. So I would first suggest you try to meet with Safe Built and see if you can come to an agreement. If you feel that their requirements are unfair or unmanageable or not legal, at that point you may consider talking to an attorney. But at this point, all the rulings have been made. You're complying with them. And I'd like to get this building finished. So Mr. Yoder is going to do several orders. Remember, you owe $2,449.34, not twice, just once. I didn't order any fine, and I didn't order anything in the 533 case. I simply ordered that those costs be paid in the 25040 CC case. Now, Mr. Thornton's going to supply me with the proposed orders that I ordered here today. And when I get them, I'll sign them. You can look at those. If you have any challenges, you can do it. All right. Now, your request for equitable relief has not been granted or denied. So if you meet with Safe Built and they won't let you do what you want to do, and you don't feel it's fair, you can ask for relief in the 533 case. You could benefit from an attorney, but I can't compel you to hire an attorney. I don't like when people are practicing law without a license. I think you got taken advantage of. I think you're in a much worse position than you would have been had you had real representation in this matter. I think we would have come to the same conclusion. I don't think you can operate a birthing center there. I don't think you can make a birthing center in the adjacent structure. So I think that would have happened regardless, but I still think you'd have been in a better position. All right, we'll be in recess. Yes?
So as far as finishing the building, it's classed already as finished.
Say that again.
I said, you said that now as far as finishing the building, it was already last hearing, it was already classed finished.
Well, it looks to be finished on the outside. What you want to get is an occupancy permit.
It stated it's a finished building.
Because it was asked, is that building?
The building is not finished. You can't use it for your intended purpose.
He said.
He who?
Joe.
Well,
Lance.
It's Lance Bonneville had said that the
building is finished.
I don't recall.
I don't recall
testifying that the building was finished and been determined to be in compliance with the. There's been no inspection.
No, it's not that it's up to date with Safe Built, but from his inspection, he classed that building finished.
All right.
I guess it
well,
is not.
If they'll give you an occupancy permit, you need to get the building permit. It isn't finished.
It is not. There's no trim on there. The
Yeah.
kitchen ain't done. The bathrooms ain't done.
Yeah,
no
so it's
toilet
not
set.
finished. So it needs to. I don't know what he said. I don't remember
Yeah,
him
he
saying
said
that.
right
but-
there.
He said right
Well,
there,
but it is finished.
he said the building's complete and it has no kitchen and there's the most gorgeous kitchen in there.
All right. Well, I'm sure it'll be very nice. It looks nice from the outside. I want you to finish it. I want you to get a building permit. I want you to comply with what they request. I want you to get an occupancy permit and live in it. All right, we'll be in recess.
Huh? Guarantee yourself.
You complete, right?
Yes.
Yeah.